This podcast is brought to you by PLI, the Practicing Law Institute, committed to providing essential legal resources to the law school community. For more information, visit pli.edu/law school.
Hello, everyone. I'm Anastasia Boyko, and I am the host of PLI's How to Navigate Law School podcast. How to Navigate Law School is your podcast guide to unlocking the hidden knowledge and practical skills needed to succeed in law school. We connect students with valuable insights from experienced professionals, decompress law school's unwritten rules, and create a supportive community empowering students to confidently create their future. Hello and welcome to PLI's How to Navigate Law School. My name is Anastasia Boyko and I am your host. Today I am joined by Gabriel Teninbaum, who is the Dean for Innovation at Suffolk Law School, and we will be talking about all things innovation and law school guidance. Welcome, Gabe.
Anastasia, thanks so much for having me on.
Great. Gabe, would you mind sharing with our audience your very unique journey into where you are now?
Oh boy. So I teach at Suffolk Law School in Boston. I've been there for the last 18 years. I was hired as a professor of legal writing. I'm deeply, deeply invested in teaching law students how to think about problem solving. So about 10 years into that journey, my colleague and now our dean, Andy Perlman, and I started having a conversation about innovation and the future of legal work. He had started a concentration at our law school about legal innovation and technology. For those who don't know, a concentration is like a law school major. And he was the first one to say, hey, I think the future of legal work is going to look a little different than the present. We should get students ready for that. So when Andy became dean, I sort of took over the portfolio of legal innovation and technology work at Suffolk Law, which I now share with many, many people who play really important roles in it. And I'm often just in the background. But I really think about that problem of how to get students ready for the future of legal work and how to get the legal field ready for better serving clients using innovation and technology.
That's amazing. And just for fun facts, tell our audience what you did before you got to that role. I love your Secret Service background.
Oh,
and
yeah.
Also, you did practice.
Yeah, I was a practicing lawyer at a wonderful litigation firm in Boston for a couple of years. I really enjoyed the work. And before that, I spent a couple of years with the U.S. Secret Service and had a wonderful adventure, and it was an honor to work with such amazing people and to serve in some small way. And I still keep in touch with my old friends and colleagues from both organizations. I'm proud to be affiliated with them.
Wonderful. So let's get back to innovation. Tell us about some of the courses that you teach at Suffolk Law School.
Sure. So our program has all of these different facets, and it's built around this idea that to be a successful legal practitioner, someone that delivers legal services effectively in the future, you really have to be able to do three things. You have to have a sense of the technologies that are available to you. And it may be that the technology is or isn't the right fit for your client or for your needs, but you have to have an awareness for how those things work. So I teach classes that are hands-on, that teach people how to build stuff and to actually create tangible products that are mostly prototypes, but could actually be launched into the world. And actually, I've had a couple of students who have done that. So that is one set of courses. The next is about new business models. So when people start thinking about new technologies that are more efficient, they quickly realize, wait a minute, if I do this just the right way, I could find better ways to better serve my clients at a lower cost, or to take on more clients, or to do more pro bono work. And that requires one to think meaningfully about new business models, things that are different than the traditional billable hour. So I teach classes that focus on that. And then the third and final piece that I teach about is process improvement and legal project management. And these are concepts that have swirled around industry for 100 years. Taylorism is from the 1920s. Things that were once applied to the assembly line are just as applicable, and in some ways more applicable to legal work. And there's this challenge. If you don't have the right people with the right sort of knowledge, if you don't have the right processes, you can't use the right technology. So I teach classes in all of those three buckets. And then we have a number of other wonderful colleagues who do experiential things to have students practice them in clinical environments and in externships and beyond.
I feel like many law schools and many law firms don't quite understand that you need all of those pieces together to be successful. It's not just one thing that will fix everything. I love this idea of building tools. When I was at Yale, we had an entrepreneurship and the law kind of class, right? So students had to build their own idea or business. And I found it fascinating because it was so antithetical to traditional black letter law learning. And I'm wondering if you could share, some of the insights that you've gleaned from watching students do that and some of the skills that they've been able to develop through that building and iteration approach.
It's totally eye-opening for students because my experience was quite similar to yours in law school. We talked about innovation. We talked about new technologies to some degree, although that's certainly been amped up in the last a couple of decades, but we didn't build anything. And now there's this movement called the low-code, no-code movement. I imagine your listenership is very sophisticated this way, but it used to be that you had to be a real software developer to build tools. And now you don't. Anyone can build a tool. It's no harder than using Microsoft Word, any of the various tools that people use day to day and don't think of it as computer programming. So let me give one example. My wonderful colleague at Suffolk, David Colarusso, who is one of the co-directors of our Legal Innovation and Technology Lab, built a tool called Q&A, the letters Q&A, markup.org. It is a gateway drug for legal professionals to think about building expert systems, little chatbots that power things like TurboTax or even LegalZoom are built on this sort of infrastructure. So we've introduced those tools as early as orientation. So these students are still 0Ls. And we say, hey, look, here's a new way to problem solve. Let's think meaningfully about how this could change your law school experience and your life beyond. And students get it and it resonates for them. And as they go on in their law school journey and they start to learn about things like the access to justice crisis or how stressed lawyers are with the number of billable hours that they have to crunch, they start to say, well, wait a minute, maybe we can start to use some of these tools to solve traditional problems in new ways. And students have done all sorts of amazing things. So one of my former students, Julia Rogers, was the first ever legal tech product to win on Shark Tank. She was a family law lawyer. She wrote prenups the traditional way. And she said, I can do this using some automations and charge 1/10 the cost and help far more people. And she got funded on that show and now has a very successful business. The people that I actually get most excited about, though, are people that go into more traditional legal careers and incorporate these tools. And we've had a number of those folks who have just gone out and become plaintiffs' personal injury lawyers. And they say, rather than doing every intake with me and a paralegal sitting there and us using all our time writing things down, maybe for the right people in the right scenarios, we can use an intake tool to help us get the information we need and get it sorted the right way and create a file. And they've implemented these tools in sort of lightweight ways that really make life better for everyone. So that's what I get the most excited about.
Oh, I love it so much. I would have been thrilled to have this, I think, in law school. And one of the pushbacks I got as I was building an innovation program was some traditional faculty wanted to know how this fits into how we teach law, right? Law as a black letter approach with a Socratic method. So I'm wondering how you bridge that conversation with your colleagues as to where does the innovation and the practical pieces of law practice and law practice management fit into the broader legal education curriculum?
Sure. I'm going to answer that in two different ways. One is it can be incorporated in all sorts of different ways directly into classroom learning. So, for example, that tool I mentioned, Q&A markup, is essentially a flowchart or a decision tree where one has to visualize what are the questions a lawyer would ask in this scenario to qualify someone for some benefit or to figure out if they have a prima facie case. And then from once they've created that decision tree, they can, build it into technology. And if one takes a step back, you realize that's sort of what the Socratic method does in reverse. In other words, the professor asking a student a question and then asking a follow-up question is helping them to create a mental model of what question comes after the next. And this could be done at scale. My colleague, Diane O'Leary, who is the director of our Lit Center and a wonderful scholar and thinker, wrote a book about this. And she said, here are all these different ways that law students and others can directly incorporate technology into legal education and make it meaningfully different and better. So that was the sort of down the middle way to answer your question, but I'm going to answer it all also in a provocative way. You said, how does it square? And I think the answer is also, if one's mindset is, how do we fit this into our current landscape? The answer is, it doesn't. And I think the thing that should change is not the creation of technologies that makes life better for clients and lawyers. It's the way that we approach law school pedagogy. So I've had the wonderful opportunity to be affiliated with a number of very prominent law schools, including the one that you just mentioned and one down the street from me in Boston. And the reality is that the idea of having a law student build something or create a startup or make some little access to justice tool isn't necessarily part of the worldview of what success equals when one graduates from that place. And I think when Dean Perlman created this program, I think he was filling a market failure, right? There was a gap, and he was the first one to see that gap and say, wait a minute, maybe we should teach students to do these things. So there are some truly elite law schools in US news terms that are starting to incorporate some of these things, but it tends to be what they want to talk about is policy, because what they're trying to do is prepare their students to go work at a white shoe firm and help, a Fortune 500 company come up with a generative AI policy. Wonderful, important. Someone's got to do it. Some of our students do it. What I'm interested in is the reverse approach and saying to students, hey, you're now empowered to do all sorts of things, including the things I mentioned, but also being an entrepreneurial small firm lawyer or creating your own tech startup or going into a traditional law firm and making it work more efficiently.
Yeah, and I think it should be underscored the importance of having leadership like Dean Perlman, who sees this, gets this, is from a technology background and has that approach to the challenge as he is the one in charge of helping to manage, faculty and curriculum. I think it's a really hard task for anyone who's looking at innovation in a law school, because we are approaching a model that is very entrenched in a tenure-based system. And there's a lot of value to a model like that. And so much is changing right now in the ways that lawyers practice. And I think especially the last 3 or 4 years, we've seen a seismic shift in the pressure on law schools to prepare students with regard to AI literacy and competency and how to approach their practice. And so I feel like there's this friction that's happening right now between the practice of law and law schools that's larger than it was before, right? We had this theory practice divide that weaved its way through conversations. But right now, you really do have a huge gap between students who have been exposed to these tools, who have played with these tools, and students who have not. And also the expectations of clients and thus the expectation of law firms about what kind of talent needs to be able to exit. And I wonder, you've been doing this for well before AI. I wonder how many skills and competencies remain the same, right? With AI coming to the forefront, but any competencies around judgment, right? We talk a lot about discernment and curiosity. How have those sort of always existed, and how are they even more important now with AI as the backdrop?
Today, there are some things that remain uniquely human in our ability to accomplish them well. And judgment, leadership, empathy, are all things that we as humans can still do better than the AI, although there's some suggestion that might be changing. But for now, I think the way that we can think about this is that those sorts of skills, and I'm not going to use the term soft skills because that's an inappropriate term for it, but those human skills are things that we can, should, and need to keep developing. So this, incidentally, is not new to law school. Law schools have had alternative dispute resolution classes, client counseling classes, trial advocacy classes, and most importantly, clinical opportunities where students have to interface with real live people, or at least simulated situations in a trial advocacy class, to hone these skills and to learn from experts, hey, when you said this, you should have approached it that other way. And we all still learn these things day to day. No one's perfect when it comes to these sorts of human skills. But so far as I've seen, these remain as important as they've ever been. And at the same time, as you suggested, there are certain things that the machines are just better at now. Let me give one example of that. 20 years ago, it used to be reliable legal work for a new law graduate or someone that was between jobs or wanted to live a sort of non-traditional life to do document work. You would work in a big room, you'd get paid something reasonable, the equivalent of $40 an hour, $50 an hour, and you would review documents for privilege or social security numbers, PII, whatever it may be. That doesn't happen anymore, of course, because the software is not only 1,000 times faster, it's actually better. In other words, it will process the stack of papers 1,000 times faster, but it's less likely to miss something. So I think it's important for people to recognize that those lines are constantly shifting. Technologies are becoming better at us at an increasing number of things, but there's still areas where we as humans can just do better than anyone. I want to give a shout out to a couple of folks who have worked hard on this idea. One is Allison Carroll from Northwestern Law School and Kat Moon from Vanderbilt and Shelley Reed. And there's some others that worked on this. It's something called the Delta model. And it was this idea that to be a successful lawyer in the future, it has three legs, like a triangle. And one is doctrinal skills, and that law schools have taught for over 100 years. The second leg is those interpersonal skills. And the third is the understanding of technology and when to apply it. This idea of the Delta model is this idea that we need to be able to do all those things, but they shift. And what's going to be important in one context is going to be less or more important in other contexts.
Yeah, no, I think that's so fascinating, right? When we look at it more holistically, which is why I love the new business model class approach and the LPM process-driven approach, because it all has to connect, right? I think one of the challenges I experience in law school and have seen with my own students is it's really hard to understand how the pieces all connect to what you're going to be doing, right? We dive in to the case law and then we're trying to figure out how to read cases and what's important, what's not important. But then we're not always pulled back up to figure out how that pieces together in the bigger picture. So you get this very narrow skill, but you're not sure how it all combines. And I find that approach sort of multiplies itself in the practice of law as well. You know, as we talk to law firm leaders and they're trying to figure out how to solve these issues, I think they oftentimes miss that holistic, strategic, piece it together in a model and figure out where to lean on which when, because we're taught to take compartmentalized approaches to this challenge and that challenge and that challenge. And so I'm wondering, let's pick out judgment. I think judgment has been one of these skill sets that everyone has been talking about with regard to AI, whether it's understanding that the output is what it needs to be or understanding how to ask the question. How do you think about developing and teaching the skill of judgment?
Part of it is being willing to endure the pain. And what I mean when I say that is it can be uncomfortable to be a beginner in confronting an idea. And in fact, there's a whole bunch of literature on the beginner's mindset and growth mindset, and this idea that we should recognize that when we're, say, new to law school and we're reading cases, and it's hard to figure out how to create a case brief, and it's hard to figure out what questions are going to be asked. And then from there, it's hard to figure out the context of why we're being asked, that what we're doing is developing this thing called the schema. And the analog I always think of with schema theory is this idea that if you keep seeing a tree and then a tree and then a tree, you have to trust that eventually you're going to see the contours of the forest. And we have these wonderful weeding mechanisms by only admitting people to law school that appear to have that capacity that allows us to say with fairly good judgment that people that are in law school belong in law school, they've earned the right to be in law school, and they have to be willing to endure seeing all of those trees to recognize that eventually they will perceive the forest. And I had this experience as a 1L. I remember that for weeks, I couldn't figure out, why are we reading this case from 1780 and why am I fitting it into this format and why are these strange questions coming? And then it wasn't until late in the first semester where I actually created an outline. I'm sure someone told me to write an outline later, but I hadn't. That information started to consolidate, and Anastasia maybe had the same experience. But once you see it all fit together, it's an aha moment. So I think you have to be willing to endure the pain and recognize that you belong, and that if you're really frustrated, you should always talk to classmates or professors or others, but eventually it'll show up. And then there are people to help you figure it out. In law schools, it's academic support professors. It's your individual professor that can help you get to the end line and give you that pep talk where you need it faster. Now, from there, once you have a schema, the idea is that to exercise judgment, you have to be willing to extend it in interesting ways. And you have to be comfortable taking little bits of risks. And again, this is why I love experiential and clinical education so much. Let's take a 3L student who's in a criminal defenders clinic, and she's read the 10 cases on bail hearings and, the parameters under the law that the judge has. she's never stood up in court. She doesn't know what it feels like when the room has all of these sad-looking people that are looking at you. So what you need is to develop enough confidence in people where they say, look, I understand the general contours of what's going to happen, and I might feel anxious. But what I need to do is I need to stand up and I need to, on my toes, be prepared to operate, right? And there's safeguards, of course. The judges know that there's law students. The clients know that they're law students. The clinical instructor or professor that's supervising knows that they might have to step in. But to give people an opportunity to extend themselves. So the idea is to be patient long enough that you get the contours, and then from there, be willing to take a risk. And people can do that on their own too. You don't need a law school course to do that. The idea is be a beginner, try to go out and learn something, and then ask yourself the question, what's the next thing I can do to add on to this, to challenge my understanding, to test it, and to do it in a safe way? And you gain more confidence and begin to exercise better judgment over time as you do it.
100%. I remember having a conversation with a 1L a few years ago who was frustrated that the material in contracts wasn't making sense. And I said, wouldn't it be boring if you came here and you knew how all of it worked? Wouldn't it be pretty disappointing to come into this new next level of challenge and you already had the answers? And that was my experience. When I was a 1L, I was very frustrated that I didn't have the answers, because I think a lot of what gets you to law school is that kind of mastery model where every time you take the test, it's just validation that you knew the material, right? We approach learning in a very different way before law school than after law school. And the way that our cognitive abilities shift. And because we're such perfectionists, I feel like in law school, we oftentimes abandon that beginner's mind or the I don't know of it all, right? And trying to search and understand how it fits together because our egos won't let us approach it in the other way. And so I'd love to talk a little bit about cognitive learning. I know that you're a founder of a learning tool, and so much is happening right now around cognition and memory and how to gain learning with AI pulling some of that away. I think that we've got enough research now that shows that it does compromise some level of cognitive ability. Let's talk about learning, and comprehension and how we tackle what's happening right now when it's easy to get answers from a model versus the friction and the discipline of learning in a traditional way.
This is one of my favorite topics. Over a decade ago, I started getting very interested in the science of spaced repetition. Spaced repetition is 100-plus-year-old science that's been proven in 100-plus peer-reviewed studies. And the way it works is effectively people are asked to learn information by doing things like looking at flashcards. And then an algorithm tells them the optimal moment when to review that in the future. And nowadays, we're able to use software to make it so that you're reminded at the optimal moment. So it's not so recent after you studied that it's easy. It's not so far out into the future that you have to learn it anew. And intuitively, this makes sense, right? If you're reminded about something, it makes sense that you would remember it longer and more durably in the future. But it turns out that if you sort of optimize this algorithm, you remember way, way more. Like it's not a little bit more, it's way, way more. So you remember 3 or 4 times as much information. You score far, far better on exams. So, there's one study that said on average, across different subject matter, people perform about a half a standard deviation better when they use spaced repetition versus just intuitive learning. So a half a standard deviation on the bar exam is like 8 added points on the MBE. And to put that in context, like 40% of bar failers fail by less than 8 points. So it makes a really big difference. So what I do is I incorporate spaced repetition and other learning methods, interleaving progressive review, regular assessments that are low stakes into students' educational experience. And the idea here is that we want to create a mental model, right? A schema, so that they understand how things fit in context, so that they're able to recall things in the future. Lawyering is still one of those things where you can't necessarily consult with a phone or a computer. Most courtrooms don't even allow a phone or a computer with internet access on. And when the judge says, what's the case that stands for the proposition that you're making, you have to know it. Or if you're handling a complex products liability case and someone asks a question about the underlying science of the tool, it's information that you're expected to have learned. So lawyering is one of those sort of last bastions of people actually having to use their brain without the aid of computers at some point. So spacedrepetition.com is one of the reflections of how I think about those things. And incidentally, there was just an article in the San Francisco Standard about this problem of AI brain rot and this idea that these tools make life too easy. I must admit, I've fallen victim to this too. It's really easy to type into, one of the many LLMs out there, write me an email that does X, Y, and Z, and it'll write you a really good email. But what it robbed you of was the opportunity to write a great email. And for some things, that's fine. For other things, you really need to make sure that you're engaging your expertise and your wisdom and your experience and your judgment. And that brain rot is a problem. And it'll continue to be a problem that probably gets worse as these tools get better and better. And it becomes more attractive to just substitute what OpenAI says your answer should be versus your own answer. So again, my antidote for that has been spaced repetition and other similar tools that allow people to think better. And for me, that's more satisfying. It's not as efficient in all instances. It's more efficient on exam day, but it's hard work to do the work of learning, but it pays bigger dividends.
Yeah, I also love how prescient you were to develop this before AI came in and made it.
Lucky is what I was. Lucky.
I'll call you prescient. But it's also interesting. I feel like AI, thinking of AI as a medium versus a tool. The work of Abby Abomosu, who writes about how not to use AI, her latest Substack was all about, understanding what the medium is doing and where the grooves are pulling you toward to get distance away from it, right? To know what it's actually getting you to do and how it's getting you to think so that you can actually use your own brain versus leaning into how it's thinking for you, which is true for any medium we use, right? It optimizes us to behave in a specific way. And I think for lawyers especially, right? We're there to learn problem solving and judgment and law school. So it's even more paramount for us to understand how these technological mediums work and where we need to get distance and where we need to put in more reps, because now it's become easier with these tools to atrophy parts of our brains. I wonder how you think where are we going to be in the next 5 years with education and learning and lawyer development? I mean, it's hard to predict, right? Because everything changes at the speed of light at this point. So I wonder how you're thinking about additional skills that you've seen either atrophy or have need for development over the next 5 years.
Yeah, I think it'll be a bimodal distribution, to use an academic term. So I think people that have the benefit of a really strong education will make smart and intentional decisions about areas where they should be additionally analog. And if you think about the work of someone like Cal Newport and Deep Work and, World Without Email, and being very intentional about when technology makes sense and when it doesn't make sense. Incidentally, Kevin Kelly, who started Wired Magazine, is really sort of a fascinating thinker, is one of the deepest researchers on Amish culture in America. And he's not Amish, but, Amish culture is largely based on intentionality around technology. It's not anti-technology. It's anti-technology that degrades the lifestyle that they've chosen for their community. So I think that people that are best educated will be those who make smart decisions about when to go analog and really do that wisely. Then at the other end of the spectrum, for those areas where technology makes sense, I think we're going to crank the knob up to 11. And there are remarkable opportunities that have never before existed for everyday people to just change the entire arc of their future, their client's future, their community's future, and in relatively painless ways. And let me give one local example. To Suffolk, we have this legal innovation and tech lab, which operates like a clinic. And David Colarusso, who I mentioned before, and his co-director, Quentin Stainhouse, they run this lab and they teach students how to build automations. And we partner with courts and legal aid organizations, and they build intake tools or tools to build a responsive form so that someone can fill out an eviction defense document. And then we've partnered with a technology company, Tyler Technologies, which, does most of the e-filing. And it allows us to create tools, which we give away absolutely for free to indigent people so that they can get legal support that they've never had before. So David, Quentin, and their, team of students has had something like 44,000 forms across our, jurisdictions filled out, downloaded, and filed in courts over the last few years. So I joke, but it's not really a joke. If they were a law firm, they would be the highest volume law firm in the country. And it's, 2 full-timers, a few wonderful part-timers, and 8 plucky law students, none of whom have a computer science background. So we need to do more of that on the digital end of things. And again, on the other end of things, more of the analog. Where analog makes sense, we need to do more of the analog.
Yeah, I love that example. I also feel like there's this tendency to want to get a through line about what's going to happen in the future. And I find when people ask me that question as a futurist, my answer is both, right? We are going to have to get more analog, and we're going to have to accelerate, and we're going to have a bunch of AI native firms, and we're still going to have firms that exist and double down on what they do really well in legal advice, right? I think the desire is always to want to go toward one particular direction, but this is really bifurcating where we can go, where we should go, who is best enabled to do so. And I think helping students realize that they have so many different paths in front of them now that they never had before is really exciting, right? Because before, I think there were some traditional ways outside of law school, and it didn't really account for students who were a little bit more curious, a little bit more entrepreneurial, a little bit more out of the box. And that's actually the thinking that we need right now, right? Original thinking is what we need more and more of right now, because I think we are actually going toward a mean of fairly mediocre thought as AI is forcing us in that kind of average direction. And so it's nice to have these opportunities to pull some of those original thinkers off of the traditional trajectory and also show meaningful application. In the case of the lab, actual people are getting real help every single day on something that is a deep friction point in the access to justice gap, which many students don't get as much exposure to as they should, given our overall professional responsibility.
Yeah, professional responsibility is a good term. So your listeners probably know this, but I guess about a decade ago, the ABA had a new comment to the basic rule that, rule 1.1, you have to be competent to take on any case that you choose to handle. And then they added a new comment that shall include being aware of the risks and benefits of relevant technologies and effectively having a conversation with your client about them. And I think the ABA got that rule right. It's not a mandate that you use technology. It is a mandate that you be aware of technology. And then from there, you take that information and you make an intelligent decision with your client. And what we've done at Suffolk, I think, is we've extended that into the actual legal education process. Of course, the ABA rules of professional responsibility, that particular rule has been adopted, I think, in 41 or 42 states, but it's not really applicable until people graduate. But my view is, and I think Suffolk's view, is that it should be applicable at day one of legal education. And that's a really serious thing to get people up to speed on that. But I think that's what ultimately will make the difference. And again, if a lawyer says, look, in this area, here's the risks and benefits, and client, what do you want to do? And the client says, let's do it the old-fashioned way. Okay, as long as it's still within their best interest and they're willing to foot the bill, that's okay. And if a lawyer says, I only want to do this sort of matter, at the very least, they just have to make sure that clients are aware of that. And from there, they should be able to make their choice. And my view is that by having this general awareness, you choose a practice area, you say, what are the tools that are here or appear to be arriving? And let's have a conversation with the client about whether we should use them. That's the way to go. And incidentally, we have that analog in our everyday life. I mean, you go to your annual physical and the doctor says, hey, look, there's some guidelines here. It's your body. It's your decision about how you want to do about X, Y, Z. The guidelines seem to suggest, A and B are the best ways to approach this. I recommend A for these reasons. You might consider B for these reasons. And then the good doctor will look at you and say, what do you want to do? Right? It's your health. And that's what we as lawyers should do, in my view, is we should do that with technology. And that will lead to some interesting and I think beneficial changes if we do.
Yeah. I mean, I love this approach. And I think that this is also a reminder to legal employers, when you're looking for talent in law school, you want law students who are taught in these ways, right? Who are given this big holistic approach with lots of skill sets and schemas and judgment to do what is coming up, because there isn't a blueprint for how to do this. And so as firms recruit, like, this is what I remind them of is find labs and institutions who have doubled down on this and have invested time and energy in this, because these are the students who are going to help you navigate the future of your firm. And so we're coming up on the end of our time together. The question I leave everybody with our podcast is, what advice would you have for your former law school self?
Be patient. Be patient. I think, as you alluded to, one of the challenges of being a lawyer is it tends to draw a certain type of person, and a person with high expectations for themselves and high expectations of what they can do in their professional life and high expectations of what they can do for their clients. And the reality is that maturity is nothing that you can rush. You can't rush the cadence on learning judgment, on making smart decisions. And what you can do is you can put yourself in a position where you can grow, but growth takes time, right? And the reality is if you want your crop faster, planting twice as many seeds doesn't get you there any faster. And you have to just recognize that certain things take time, and that can be frustrating and challenging, but, enjoying that process and recognizing it is a process that one's undergoing, I think, is the advice I would give myself. Whether I follow it or not, I don't know, but it is, I'm now convinced, looking back, the right advice.
Oh, brilliant. Thank you for joining us, Gabe. This was a fabulous episode and so many great little treats for our audience.
Anastasia, thank you. Thank you to PLI. It was terrific to be with you.
Thanks for listening to How to Navigate Law School, the podcast dedicated to guiding you through the hidden rules and practical skills essential for success in law school. For additional resources, visit PLI's Law School Hub at pli.edu/law school. Please note that the views and opinions expressed during this podcast represent those of the individuals being interviewed and not necessarily those of PLI. PLI is a nonprofit learning organization dedicated to keeping attorneys and other professionals at the forefront of knowledge and expertise.